Hello and welcome to Verdictum. I am Ananya Singh and today we have with us Senior Advocate Vivek Sood. Vivek sir is well known for his expertise in diverse branches of law, including constitutional, commercial, technology and criminal laws. He is also a celebrated author and has written on various subjects like cyber law, right to privacy and more. His objective is to make law understandable for laymen. And today he is with us to talk about his latest book, Chaff and Grain. Welcome to Verdictum, sir. It's an honor having you.
Thank you for bringing me on this platform. It's a pleasure to be here.
Sir, I'll start my line of questioning with your book. Please tell us about Chaff and Grain. What is it about and what inspired you to write it?
Chaff and Grain is my 7th book. It is closest to my heart. And the book is about the functioning and malfunctioning of the Indian criminal justice system, or if you may call it, criminal injustice system. So it's about, I have picked up some hot topics, hot subjects that confront the Indian criminal justice system today. For instance, I start my book by examining these fake cases, false cases that enter the criminal justice system. And I have selected 3 categories in this chapter. One is the misuse of rape laws in the country. It's become rampant. Secondly, the abuse of the scheduled caste, scheduled tribe laws, atrocity laws. Again, that has become rampant across the country. And thirdly, the misuse and abuse of the law of cheating. So many civil, business and property disputes are converted into false cases of cheating to put pressure on the accused. So these are the 3 categories of false cases I've selected in chapter 1. I have examined, cases, I have given examples, instances, case studies, and then I have made out a case for reforms. That, how we can reform the criminal justice system, how these false cases can be weeded out or how they can be reduced to the minimum. Then I go on to, discuss a very interesting topic, and I have coined this expression in Chaff and Grain. It's malvestigation. The problems in the area of investigation in our criminal justice system. Investigation is the backbone of a criminal justice system. If investigation is good, the outcome will be fair and correct. If the investigation is shoddy, dishonest, corrupt, incompetent, you will never have the correct result at the end of the trial. Here I have selected some very, hyped cases, media hyped cases like Priyadarshini Mattu, Jessica Lal. And then I have gone on to, to unravel the mystery in Arushi Talwar's case. Who killed Arushi Talwar? In my view, I have given my view. I have given my take on this case. I have examined the verdicts of the Sessions Court. That is the verdict of conviction. Then I have also examined the acquittal verdict of the High Court, Allahabad High Court. Which verdict is correct in my view? So I have given my take on this case. Then I have gone on to address a very complex area of criminal justice. That is bail not jail or jail not bail. There is a dilemma. There is a dilemma, bail not jail or jail not bail. I have addressed this issue. Then I have gone on to address a very important issue that has not been touched earlier. This principle of chaff and grain. It's a principle of necessity. It's a doctrine of necessity for the Indian criminal justice system. It has been evolved by our Supreme Court because, in India, all witnesses commit perjury. The Supreme Court has gone on to say that every piece of evidence, every testimony is full of falsities, embroideries, exaggerations, embellishments. So therefore, the judge has to separate the chaff and grain to find the truth. And he has to decide based on the grain that he finds in a case. Unlike in the American legal system, where if a witness lies on any one material aspect, the whole testimony is rejected. So I've critiqued this principle of chaff and grain, although it is a principle of necessity, but then it may lead to conviction and punishment of innocent people also. And I have given actual case studies where I feel that perhaps the innocent man was convicted and punished. Then, after this, I have gone on to address the most contemporary issue that confronts our justice system today. How to define social media abuse. It's a challenge. It is a challenge for legislators and policymakers across the world, including India. So I have actually defined social media abuse for the legislators to consider. Do we need a law of sedition in India? I have addressed this question. And I have also redefined the offense of sedition for the policymakers to consider. And so that the law is not misused by the police, what are the checks and balances required in the justice system so that the law is not abused? Then I've gone on to address a very interesting subject, a very hot topic about which we read every day. The legality of arrest of people. We read in everyday newspaper, so-and-so man was arrested, so-and-so person was arrested, he was picked up, etc. What is the legality of arrest? And how the police is not following the judgments of the Supreme Court in Arnesh Kumar and other cases. And then finally, I have addressed the issue of fake encounters. I have taken that case study of the Hyderabad, where there was a brutal rape murder of a doctor. And 4 or 5 men were caught and they were shot dead in an encounter. The police claims it to be a genuine encounter. However, a committee of the Supreme Court, headed by a retired judge, has found that prima facie it was a fake encounter. So these are the issues I have addressed in Chaff and Grain. Now, what motivated me to write this book? Every day when you open the newspaper or you open your television set, it is full of crime stories. Arrest, bail, acquittal, conviction, punishment, investigation, police. So the criminal justice system is a big chunk of the news we get. And most people are so interested in the crime stories, crime incidents. So I wanted to give a perspective of the Indian criminal justice system to the people at large. Therefore, the book is not written only for the legal community. It is for anybody to read who is interested in the subject. And secondly, I found that there is not a single book on the Indian criminal justice system. I could not find one on the bookshelves. So I chose to write on this subject, which is contemporary, very challenging, and very controversial at the same time.
So, talking about the issue of fake cases in particular, do you think that laws relating to sexual offences, Dowry Act, POXO Act, Domestic Violence Act, Prevention of Atrocities on SC/ST Act, that were made to empower weaker sections like women, minors, SC and ST, have done more harm than good as was expected from them when they were made?
I don't think so. I feel that they have done more good than harm. See, these laws are necessary. I'm not arguing. I have not said in my book that these laws should be scrapped or repealed. Not at all. They have a laudable objective. But apart from the good that these laws are doing, they are empowering the weaker sections. They are empowering the women against all kinds of atrocities, rape, molestation, etc., etc. But at the same time, a lot of abuse is happening. So we have to check that abuse. We have to minimize that abuse. That's what my book talks about. My book is not saying that, you must repeal these laws or take off these laws from the statute books. These laws have a purpose. They have an objective to fulfill, and they're doing a lot of good in the society. But at the same time, they're also being misused and abused.
So, in this context, do you think that there was a time when these laws were misused rampantly? Like it was a settling down time, and now the courts have been watching these cases very cautiously and not giving easy relief to the petitioners.
I think it is still a far cry. Criminal justice with respect to these false cases is still a far cry. We have miles to go. But definitely, the superior courts have begun to see through this misuse and abuse of criminal process, criminal legal process. I would not say that things have settled down. We are still in a state of turmoil, turbulence, manthan, as if you may call it so. But it is the awareness of abuse and misuse of these laws is growing rapidly. But still, lots needs to be done. Especially, all this abuse must percolate at the lowest level, that is the district level judiciary. It is not only the superior courts that can keep a check on the rampant abuse of these laws. The magistrate before whom the arrested man is produced for the first time, or where the bail application is filed for the first time, or the sessions court, they also have to be made aware of the abuse of these laws, these and many other laws.
So, you also touched the issue of fake encounters. The Human Rights Commission has been very active, and courts have become harsh on this issue. Recently, Allahabad High Court has awarded life sentence to 43 cops, and Telangana High Court has ordered for trial of all cops involved in the Disha encounter case, which you mentioned. In contrast to past when encounters were done for personal benefits of policemen, now they're sort of state sponsored as public pressure is high on the elected government. Examples like Vikas Dubey was encountered and Disha case when public was demanding instant justice. Do you think that these encounters are demanded by public and done by state due to lack of trust in courts, who, as per public perception, can be managed by criminals, and because there is no timeline as to delivery of justice?
I would not agree with this statement that these fake encounters are happening today, or they are, happening more rampantly in these days, or the state is involved in it, or the government is involved in it. I don't think so. I don't think the government or the state is involved in it. I don't think, and I would not like to draw a comparison. If you go back in the past, in the state of J&K, or in the state of Punjab, and in the state of Northeast. So these fake encounters, have been there since a long time. Governments will come and go. Governments have come and gone. Governments in future also, governments will change with the elections, etc., etc. So the issue which I've addressed in my book, Chaff and Grain, is not to draw any kind of comparison or this public perception, etc. What I say, I picked up the case of Telangana, where the doctor was brutally raped and murdered, and four or five men were arrested, and ultimately they were encountered. Now, whether the encounter was genuine or fake, the matter is sub judice. But prima facie, as per the retired Supreme Court Judges Committee, prima facie, it appears to be a fake encounter. Now, what I say in my book is post that encounter, the celebrations that took place across the country, very unfortunate. It speaks of the unawareness amongst the people. We have a criminal justice system in place. We should never try and bypass that criminal justice system. It may be tardy, it may be slow, but justice does catch up. Let me give you two examples. Kasab, there can't be a more heinous crime than committed by those Pakistani terrorists, when they attacked the Taj Hotel in Mumbai, killing so many people. It was almost a genocide that happened. But he was again given a fair trial. And after a fair trial, he was hanged until death. Let me also give you an example of Nirbhaya case. It was a brutal rape murder of that lady, by those brutes, those devils, I would say. But they were put to trial. Now, in that trial, one of the accused was found to be juvenile. He was let off. Now, assume if all of them had been lynched or encountered by the people or the police, what would have happened? Maybe out of those four or five people who were encountered in the Telangana case, maybe one or two may have been innocent. So in my book, then I've drawn comparison, with the unfortunate murder of the small child in Ryan International School, Gurgaon. Unfortunately, the bus conductor was picked up. Had he been lynched by the public or by the legal community or by people or the police while taking him to the court, ultimately what happened? He was let off by CBI. And eventually, some senior student has been accused. So these encounters, in my view, it's a complete bypass of the criminal justice system. Of course, I'm not saying there should not be any encounter. After all, there would be cases of genuine encounters. When the police is chasing these criminals, these hardcore criminals and terrorists, they can't be expected to be handcuffed. There are situations where these encounters are born out of necessity. But I feel that fake encounters should be deprecated, and they have been deprecated by the courts. In fact, cops who have been found guilty of committing fake encounters have been punished by our criminal justice system. So I would not, want to generalize that it's the public pressure and the state is under pressure of the people, and therefore we are having more fake encounters. It's too broad a statement, too vague a statement for me to accept as a lawman. I'm a lawman. I will go on a case-to-case basis. And for me, everything boils down to evidence and material. I can't speculate. I can't just talk in the air.
So you also highlight on the issue of social media abuse. Do you think that the current system is well equipped to deal with the mammoth of problems that social media comes with, if it is equipped or not equipped?
In my view, in the current scenario, we are not equipped at all to deal with social media abuse. First of all, let me explain this. Section 66A of the Information Technology Act, it defined internet related offenses. Abuse of the digital media, abuse of social media, abuse of the internet. It defined and punished it. Now, in Shreya Singh's case in 2015 or so, it was struck down as unconstitutional because it violated freedom of speech and expression. It was overbroad. It was vague. It was too general. It made innocents vulnerable to being prosecuted. So therefore, it was struck down. Now, since 2015 till date, we don't have the offense of social media abuse. So therefore, I'm advocating in Chaff and Grain that social media abuse must be defined. It must be made a punishable offense. Having said so, it has to be narrowly defined. See, the moment you broadly define it, then you are curtailing the freedom of speech and expression of the people. Then you are subjecting it to unconstitutionality. So it has to be narrowly defined, and so as to have checks against its misuse by the police. You must have checks and balances in the law itself. I have also suggested those checks and balances so that innocent people who are merely exercising their freedom of speech and expression should not run foul with that law, should not be arrested unnecessarily. So I do feel that in the current ecosystem, in the current legal system, we are not equipped to deal with social media abuse. So what is happening now? When you hear of people being arrested, so all kinds of inapplicable provisions that are there in the Indian Penal Code, they are made applicable and an FIR is registered. Whether you take the case of Arnab Goswami or others. So, so you need a law. So why should you have to travel to these inapplicable laws and put them together somehow, make some pav bhaji out of it and make an FIR and just arrest the accused? You must have a well-defined law, make an offense out of it.
So you just spoke about Section 66A. Until recently, despite it being held unconstitutional by the top court, it was still being used.
Yes, I have spoken about these cases. I've spoken about these cases in my book. It is very unfortunate. In fact, the problem, now what is the problem? The problem is, unfortunately, Supreme Court judgments do not percolate to the police station, do not percolate to the magistrate's court. They don't percolate into the criminal justice system. Therefore, you have these kinds of cases every day. Even after it was declared unconstitutional in the year 2015, you have cases till 2022, maybe even now in some nook and corners of the country. Who knows, 66A would be added in some many FIRs. So that's a problem, and this problem has to be resolved. I think the senior police officers have to be made accountable. The SHOs of the police stations have to be made accountable. Some deterrence is required. Some training is required. I think it's more about training. It's more about sending that message loud and clear that now this has been struck down as unconstitutional. You cannot invoke it. And secondly, some deterrence has to also come into play. For example, haul them up for contempt of court, send a couple of cops to jail for 15 days, 20 days, 1 month, let it affect their annual confidential reports, let it affect their promotions, let them be made to pay compensation to the accused who are unlawfully arrested or hauled up under an unconstitutional 66A. So these are some measures required to percolate into the justice system we have.
Sir, you have also talked about the role of media in the criminal justice system. Do you believe that because of the aggressive media trial, the minds of laymen have not been able to capture the difference between an accused and a convict? What, according to you, does it take away from the accused?
That's a very good question. I totally agree with you. That media paints the accused, as a convict. And the lay people don't understand this basic distinction between an accused and a convict. So I would feel that, we need to make our people more aware. The media will have to take responsibility. I don't advocate any form of censorship. I don't say that, the media should be censored and all that. Media will have to be conscious about what they are saying. So, while they write against the accused, while they write the version of the prosecution, the police, they should also write that there is something called presumption of innocence. There is something called the Blackstonian principle that 10 guilty men may go scot-free, but 1 innocent man should not be punished. They should be made aware of the principle of proof beyond reasonable doubt. The prosecution must prove its case beyond reasonable doubt before you convert an accused into a convict. So, these are some footnotes required to be put in all those crime stories that we read about or hear about, so that people get a more holistic view. And that's one of the purposes for which I've written this book, Chaff and Grain, so that people are aware of what's happening. How does the criminal justice system function? How does it malfunction? What are the reforms we require, etc., etc.
So you have also coined a term malvestigation in your book. Do you think that malvestigation and slow speed of delivery of justice are the root causes of the whole problem? How much time you think will it take to achieve a stage when there is no malvestigation?
I will want to bifurcate this question into two. Let's talk about malvestigation first. definitely, things are improving. I would say there is an improvement. For example, there is much more usage of scientific evidence today. The call records, for example, or DNA evidence is being lifted in many more cases than in the past. You have much more forensic evidence, forensic tools, scientific evidence that is being applied to cases. From say Nirbhaya onwards, I can see a shift happening. But having said that, we have a long way to go. Still we don't have enough forensic labs. We don't have, our police is still ill-trained insofar as scientific evidence, scientific investigation is concerned. There is an improvement over the past, but then, we have miles to go. So I cannot put a time frame to, when malvestigation will become, fair and honest investigation. I can't put a time frame to it, but definitely depends upon the will of the government, the will of the executive. I read a lot of good things that are happening. A lot more of these labs are coming up. A lot cyber investigation, etc. A lot more scientific techniques are entering the investigative system in our country. There is an improvement. I can see green shoots, but we have a long way to go because, the number of cases is disproportionately high in comparison to the scientific infrastructure that we have. So malvestigation remains a big problem. And secondly, malvestigation is also because of the colonial mindset of the police officers that refuses to go. I'm not saying it. The Supreme Court has said so in so many cases like Arnesh Kumar. The investigating officer, he's the Brahma, Vishnu, and Mahesh of investigation. He's the god of investigation. The law is that no court will interfere in the manner of investigation. So whatever investigation he does is final. And ultimately, after 20 years, the superior courts lament at the poor investigation, shoddy investigation, unscientific investigation, dishonest investigation, unfair investigation. So I have said in my book that when the investigation is being conducted, it is at that point of time that you need to put checks and balances. I am not saying that the judiciary must interfere, but at least the senior police officers must keep an eye on the merits of an ongoing investigation rather than lamenting about it after 20 years when the matter reaches the High Court or the Supreme Court. Now, the second problem is, delay. Delay is, again, it's a problem. It's an inherent problem. Justice Chandrachud the other day has pointed out that the judge population ratio in India is very, very, very bad. It's very poor. It's very, when you compare it to the mature Western democracies, the judge population ratio has to improve. So you need more judges, more infrastructure, so that the cases can be expedited. Again, there are green shoots. You have a lot of CBI courts, for example, in Delhi. And things are improving. I would not say things are going from bad to worse. Things are improving. But we need, I think, faster pace of improvement, if we have to compare ourselves to the other mature democracies of the world. Now, the third problem, these are not the only problems. It's not that if you resolve these problems, everything is sorted out. There are so many other problems confronting our criminal justice system. One of the basic problems is the credibility of the witnesses who enter the witness box. The credibility is very low. As the Supreme Court has said, falsities, embellishments, embroideries, exaggerations, all witnesses, prosecution witnesses, defense witnesses, police witnesses, they have a tendency to commit perjury. Unless we improve the credibility of the people, and that can be done again, through spreading awareness and through deterrent measures. We have the law. We have the law against perjury. It should be activated. whenever judges find that false evidence has been given, that victim or the complainant must be prosecuted, must be taken to task, so that there is some deterrence in the society, which is grossly missing at this point of time. So people just take it for granted.
Sir, would you like to say, just to sum the session up, anything for, for reforms in the system that you would like to see in the near future?
I think for that you should read Chaff and Grain. But some of the reforms I can speak of. False cases. Let's start with false cases. The superior courts must exercise their inherent powers of quashing false cases more frequently. Whenever a case appears to be false, these courts should be more liberal in granting anticipatory bail, in granting regular bail, so that innocents don't suffer. Wherever falsity comes to light, it has to be tackled. The so-called complainant cannot get away from it. Then, insofar as bail not jail or jail not bail is concerned, I would want to see more bails being granted. Of course, not in every case. I'm not saying that bail should be granted in every case, but more bails should be granted. I'm an advocate for the principle of bail, not jail, rather than jail, not bail, but not in every case. I would want to see the investigation improving itself. We need more forensic labs. We need more, competent investigators. For example, very interestingly, I read that insofar as cybercrime investigation is concerned, we don't need policemen with badges and guns. We need those 18-year-old hackers, overworked hackers, who are with a chewing gum, and they are the good investigators. So we need competent investigators, scientific investigators, rather than police in khaki uniform. We need to define social media abuse. We need to redefine sedition. We need to put checks and balances so that these laws are not abused by the police. And then, yes, we need to, definitely control the arrests, the number of arrests that happen. Police is trigger happy in our country, and the police suffers from the colonial mindset. And again, the judgments of the Supreme Court in Arnesh Kumar and Joginder Kumar are not percolating into the justice system. So the policemen need to be hauled up. If they illegally arrest people, they need to be hauled up and punished for grossly violating this law of arrest. Because a man who's arrested, it's a scar forever. It's an ostracism forever. So therefore, keeping in view the gravity of an arrest, even for a day, I feel the policemen should be made more accountable. So these are some of the reforms that we need to introduce in our criminal justice system.
Thank you so much for such an insightful session, sir. I really hope that a lot of people can get a lot of help from listening to you. And thank you for joining us today.
Thank you very much. It was wonderful interacting with you on this platform. Thank you.
And to our viewers, thank you for watching Verdictum. For more such content, subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.